You sued your doctor for medical malpractice. And now, in one of your follow-up visits with the doctor admitted in the office, privately to you, that yes, he did screw up. And yes, he's sorry for all the problems that you had. And yes, you're going to need ongoing medical care into the future. If there was another person in the room with you, let's say a good friend of yours or a relative, do you have to disclose that information to the other side, to the doctor's attorney? What happens if you do? More importantly, what happens if you don't? You want to know the answer? Come join me on this walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you sued your doctor. You claim that he was careless, and that as a result of his carelessness, you suffered permanent harm and injury. You go to the best lawyer you can find, who has your records reviewed by a medical expert and confirms that yes, you do have a valid case. Now, your attorney starts a lawsuit on your behalf. During the course of your lawsuit, you will be questioned by the attorney who represents the various doctors or hospitals you have sued. This is a process called a deposition. It's really a question and answer session that's given under oath, and it typically in pre-COVID times takes place in your attorney's office, in his conference room. Okay? During COVID times, this usually will take place now on a Zoom video call. Now, during this question and answer session, the answers that you give in response to questions by the opposing attorney represent your sworn testimony, and it locks you into your testimony so that a year or two down the road when your case gets to trial, when you are asked the same or similar question, if you now give a different answer, you will have contradicted something that you said a year or two earlier. Importantly, the answers that you give not only represent your sworn testimony, but carries the same exact weight as if you are testifying at the time of trial in front of a judge and in front of a jury. During the course of questioning, the opposing lawyer asks you questions about the conversations you had with your doctor in follow-up visits after the wrongdoing happened. And now you have testified that the doctor has actually admitted that he did something wrong, admitted that he was careless, admitted that he was sorry for what occurred and should never have occurred. And now, you explain all of this in great detail to the defense attorney. The defense lawyer then asks, was anybody else in the room with you? And now, you have a mental thought in your mind, oh no, what am I going to do? I know for a fact, you know for a fact, that there was somebody else in the room. It wasn't a nurse, it wasn't another doctor, it was a friend of yours, or it may have been a relative of yours. And they were there with you listening to every single thing the doctor said. For a moment, before you actually open your mouth to answer, you think that if you answer yes, there was somebody else there. Now you are going to have to involve your friend or your relative into the details of your lawsuit. And you think that by doing that, it's going to harm your case, or that now the defense will want to go ahead and question your friend or your relative to find out exactly what they remember about that conversation. And you know something? I want to share something very important with you. The answer to that question is yes, it does matter. It will matter. Why? Because if there is somebody in the room with you who can now corroborate every single detail that you discussed just now, that will help your case. It will help to show that that conversation took place. It will help to show the details of what the two of you spoke about. And it simply gives confirmation of exactly what the doctor said and the circumstances under which he said it. If you choose, for whatever reason, not to involve your friend, and now you turn around and say, no, there was nobody else in the room, well, one of two things just happened. Either you intentionally told something that was not true, or you temporarily forgot that there was somebody else in the room with you. Okay? One of those two things have just occurred. Now, months down the road or weeks down the road, I will have a chance to question the doctor whom you have sued. And I will certainly ask him questions about that conversation that took place that you described in such great detail. And one of the questions I will ask is whether there was anybody else in the room with you at the time of this conversation. And I will ask the doctor to either confirm or deny those specific details that you so eloquently described. If the doctor says he does not remember anybody else being there, and now you have already testified and said that there was nobody else in the room, what you have really done is you have shut out the opportunity to have someone else corroborate and confirm the details of what the doctor said and admitted to you. Plus, I'll tell you one other problem that you've created now. If your case now goes all the way to trial, and you have failed to disclose to the other side the fact that there was a witness there who can confirm every single detail, and now you decide, oh yes, wait a second, I now remember, my uncle was there with me, my best friend was there with me, and he knew every single detail of every single event that was discussed during that conversation. Well, guess what? If you plan on calling your uncle or your best friend to now come into trial and testify as a witness on your behalf, before ever disclosing his name, before ever disclosing the fact that somebody else was in the room, you know what's going to happen? The moment your attorney yells out, Your Honor, we call Mr. Gonzalez to the witness stand. And who is Mr. Gonzalez? Oh, he's somebody who is in the room who can now confirm and corroborate everything that my client has talked about. Well, you know what's going to happen next? The defense attorney is going to jump up out of his chair as if an ejection button was pressed and yell out, Objection, Judge! Mr. Oginski and his client never disclosed that there was a witness in the room. In fact, his client told us specifically that there was nobody in the room. We've had no notice, no advance warning that there was a witness in the room. We ask that you preclude and prevent this witness from getting on the witness stand. And you know what the judge is going to do? He's going to turn to us and say, Mr. Oginski, is that true? Well, yes, Judge, that is true. All right, your witness is prevented from testifying. Call your next witness. So what have you done? What you have done is now you've limited the ability for you and your attorney to call this witness who apparently had crucial information to come and testify on your behalf, to explain exactly how this doctor admitted all the things that you said he admitted. By failing to disclose this during the course of discovery, when depositions were taking place, and when attorneys were required to turn over information, such as whether there were any witnesses to the events that transpired. If you fail to disclose that, and your attorney fails to disclose that, you will be prevented from ever calling this witness at the time of trial. So, is it going to affect your case? The answer is it certainly could, because now you have withheld crucial information that might have helped you. It might have helped the defense. The reality is, we don't know, and you won't know. Why? Because for whatever strategic reason, you decided that it was better not to involve your friend, but now you had a change of heart, and as you got close to trial, realized, you know what? I want to go ahead and call this witness, so let's do it, and let's ambush the other side with this witness who's going to be helpful to our case. Why do I share this with you? I share it with you just to give you a warning about what could happen if you failed to disclose witness information and you plan to save this information until the time of trial, mistakenly thinking that it's going to help you and your case when this witness gets up to testify and the defense won't know what hit them. Well, guess what? That's absolutely incorrect. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.